Legal expert Benedict Phiri joining us now. Benedict, always good to have you on the show. So what are the options now? What's the legal avenues that the former president and his team can now explore? Good morning.
Good morning, Gareth. Unfortunately for the former president, his options are quite limited at this point in time. I do anticipate he will probably apply to the Constitutional Court to hear this leave to appeal, because, as we know, he had raised some constitutional questions within this question of title to prosecute, and it was anticipated when the matter last appeared before Judge Pete Koen.
Because the National Prosecuting Authority obviously are welcoming this decision. They want to get this court case underway as quickly as possible. The eNCA president also, Benedict, saying that denying any claims of deliberate delays in the Zuma case, and many people suggesting that there actually have been deliberate delays. What do you make of that comment by the eNCA president?
Yeah, when the delay was, ventilated in court before Pete Koen, it became pretty clear to me that we couldn't make much of the delay, other than that there had been maybe an administrative glitch within the court system, which happens frequently for us that are in the courts weekly. So I'm pretty sure that explanation is genuine and accords with sometimes these administrative glitches that we experience as practitioners for our clients in the courts.
I'm seeing as well a spokesperson for the RSA Judiciary, Nathi Mkube, saying it's unfortunate that the delays in not just this matter but one of the other matters that the court is dealing with have been directly attributed to the president of the eNCA. So you're talking issues and delays with in-court procedural issues, but what do you make of some of the criticism that the eNCA president was attempting to delay these matters? They're saying it's unfortunate from their office.
I think it's certainly unfortunate that, we can take a delay. If you understand the reasoning that was issued by the Office of the Chief Justice around the fact that actually the registrar had indicated incorrectly and had not carried out the president's instructions with respect to the hearing of this reconsideration application, or at least it being put to her. So I think, if you think of it like that, I think it's a little bit unfair to really put them at the door of the President of the Supreme Court of Appeal. I think even within matters passing through into judges' offices, files being delivered into the judges' offices, sometimes documents get lost, files don't make it there on time. We experience this frequently, and I think it's actually unfortunate that these delays were put at her door when they actually could occur in any normal circumstance.
So what now happens when this court case resumes? What are the matters that you imagine the defense, in this case the lawyers for the former president, are going to bring forward? Is everyone, in theory, ready to now go after this dismissal by the eNCA president?
Well, I don't think we're going to get there very quickly, because I think two things are going to happen on the part of the former president. The first is that he will then approach the Constitutional Court to hear the matter. I think that'll be slightly more delayed and a little bit closer to the next hearing date before Judge Pete Koen, and obviously within the time limits applicable for the bringing of that application. And then I think what we're going to see is a ratcheting up of pressure from the former president's legal team on the NPA, requesting that certificate of non-prosecution of Billy Downer for leaking the former president's medical records. I think what you're going to see is a little bit of pressure around that front, because ideally what the former president would like to do is probably commence any private prosecutions before this matter resumes before Judge Pete Koen.
And when we now take a look at some of the delays that are levelled against the former president, deliberately delaying this court case is what many sectors are suggesting has happened. Benedict, how difficult is that for a court to prove? Is that something that a court would look into, that a deliberate delay by either the legal team of the former president is exercising at the moment? Would they even go down that avenue? What could they do about that? How do they even test for something like that?
Yeah, the Criminal Procedure Act sets out the test for an unreasonable delay, or rather the factors that are taken into consideration for an unreasonable delay in criminal proceedings. And then the judge may obviously order that whatever is causing that unreasonable delay is ameliorated and the trial proceeds. But in this particular instance, the delays are really as a result of legal avenues open to the president and ones that he can exercise within his right. So within this context, an appeal to the Constitutional Court would not constitute an unreasonable delay of this matter. But obviously, we would hope that the Constitutional Court would hear that expeditiously so that Piet Koen can resume with the matter as soon as possible.
Well, as always, I really appreciate your time joining us, legal expert Benedict Phiri. Off the back of that news, the NPA welcoming the reconsideration decision in the Jacob Zuma corruption trial.